Nous commençons notre panel.
We start our panel.
Je suis francophone, c'est pourquoi je parle en français. Et heureusement qu'il y a quelqu'un pour interpréter.
I'm a French-speaking person. Fortunately, there's a person to interpret it.
Moi, c'est Dieudonné Kamuleta.
My name is Dieudonné
Kamuleta.
Kamuleta.
Je suis le président de la Cour constitutionnelle de la République démocratique du Congo.
I'm the president of the Court Constitutional of Congo Republic.
Je vous dis merci
I thank you.
et aux organisateurs aussi pour cette opportunité qu'on nous offre.
I thank the organizers for this opportunity that offer me.
Surtout en voyant le thème qui est attribué à notre panel.
Because they sent me the term that is attributed to my panel.
Les cours constitutionnels en période de péril démocratique.
The Court of Constitutional in
En période de péril démocratique.
on a period of democratics.
Indépendance judiciaire et sécurité personnelle.
And independence. Okay.
Non, je connais. Non, mais tu es libre.
D'accord.
Tu es libre.
D'accord. Bien. Oui. Vous pouvez continuer.
Les mots-clés, c'est l'indépendance judiciaire et la sécurité personnelle.
La palabra clave es la independencia judicial y personal.
Là, on parle beaucoup plus, nous mettrons l'accent sur les cours constitutionnels.
Ahí estamos hablando del el costo del constitucional.
Mais pour moi, ce thème m'intéresse à double titre.
Pero para mí ese tema me interesa doble.
J'ai dit que j'étais le président de la Cour constitutionnelle de la République démocratique du Congo.
Como yo le he dicho, yo soy el presidente del Corte de la República Democrática de Congo.
Mais en même temps, je suis le président du Conseil supérieur de la magistrature.
Y a la misma vez, yo soy el presidente superior del Suprema Corte.
Donc, chez nous, le président de la Cour constitutionnelle, c'est lui qui dirige le pouvoir judiciaire.
En donde nosotros es el presidente del Corte Constitucional que dirige el presidente
De tous les magistrats.
de todos los fiscales.
OK. Et à ce titre-là, comme je suis magistrat de carrière,
Y a ese título, como yo soy fiscal de carrera,
je verrai ce thème-là globalement, pas seulement pour les juges constitutionnels,
yo voy a ver ese tema de manera global, no solamente de forma constitucional,
mais en parlant de magistrats tout court.
pero solamente hablando de un fiscal solamente.
Nous savons tous qu'en ce moment-ci, avec l'évolution sociale,
Sabemos todos este mes como con la evolución social,
les cours constitutionnels deviennent pratiquement et à la fois des lieux de secours et aussi des cibles.
los cortes constitucionales llegan a ser lugares de socorro y también lugares que están tienen un enfoque.
Le problème qui se pose, c'est de savoir jusqu'où peut aller cette indépendance,
El problema es saber hasta dónde se puede llegar esta independencia,
quel est le prix à payer,
cuál es el costo a pagar,
quels sont les mécanismes constitutionnels et légaux qui sont mis en place pour sécuriser et garantir la dite indépendance.
cuáles son los mecanismos que están para garantizar esta independencia.
C'est à ces quelques questions-là
Con estas algunas preguntas,
que ces éminents panélistes vont répondre dans leurs interventions.
estos panelistas van a contestar en sus intervenciones.
Et ensemble, après ces interventions, nous allons tous interagir pour voir qu'est-ce que nous pouvons retenir de base pour ce thème de ce panéliste,
Después
de ce panel.
Después de todas las intervenciones, nosotros vamos a reaccionar juntos para ver qué podemos retener de estas intervenciones de los panelistas.
Merci beaucoup et je souhaite déjà courage aux panélistes.
Muchísimas gracias. Yo los deseo suerte a los panelistas.
Tout en leur disant que nous restons pratiquement accrochés à ce qu'ils vont nous dire pour que nous puissions sortir de cette activité enrichie.
Yo estaré pendiente de escuchar todo lo que ellos van a decir para nosotros poder salir con esa actividad, con muchísimas cosas para enriquecernos.
Merci beaucoup.
Muchísimas gracias. Y ahora vamos a empezar con el orden de los panelistas.
Je prends l'ordre qui est ici,
Voy a tomar el orden que está aquí.
ou comme nous sommes là, je peux commencer par la droite ou la gauche au lieu de prendre ce qui a été fait.
Como yo estoy ahí, yo podría empezar a la derecha o a la izquierda en
Parce
vez de
que
tomar con lo
ici,
que ya
dans le
estaba
programme,
establecido. Porque aquí en el programa
Madame Anita.
En el programa tenemos a la señora Anita.
Et après, il y aura M. Rizine Robert.
Después tenemos al señor Rizine Robert.
OK. Ah oui. Et à M. Adelino Manuel Muchanga.
Y al señor Adelino Manuel Muchanga.
Il y aura aussi M. Ilir Rusi.
Y también tendremos el señor Ilir Rusi.
Et à le collègue Roberto Molina Barreto.
Y también tenemos nuestro colega Roberto Molina Barreto.
Et enfin, M. Sokol Berberi.
Y al final, el señor Sokol Berberi.
Donc, je crois qu'on peut respecter cet ordre-là comme tout le monde est présent.
Voy a respetar ese orden como todo el mundo está presente.
Nous prenons Madame Anita Odiņa.
Empezamos con la señora Anita Odiņa.
Je signale qu'elle est docteur en droit de l'Université de Lettonie depuis 2007.
Ella tiene un doctorado en Derecho en la Universidad de Letonia.
Et qu'elle draine derrière elle une riche expérience professionnelle.
Y ella tiene una experiencia muy rica profesional.
Elle est présentement juge à la Cour constitutionnelle de la République de Lettonie.
Y actualmente ella es fiscal en la Corte Constitucional en Letonia.
Elle a la parole pour nous faire vivre l'expérience qu'elle a pu drainer pendant toutes ces années.
Ella tiene ahora la palabra para hacernos vivir esa experiencia que tiene durante todos estos años.
À vous la parole, madame.
Ella tiene la palabra.
Yes. Thank you, dear chair, dear colleagues, dear panelists. It's nice to be here. First time in such a beautiful country. And therefore, first of all, I would like to send warmest greetings from my country, which is far away from here. But anyway, we love saying that we live in very challenging times when various crises consistently endanger personal safety in broader sense of this term. As the history has shown us, deviations from normality and the resulting endangerment of safety of persons seems to follow one another. COVID-19 pandemic, progressively increasing consequences of climate change, and also from my country's perspective, Russia's war of aggression in Ukraine are just some examples. It is without a doubt that such events threaten the democratic state order or even the very existence of many states. It means that states should be able to react to those threats. What my brief intervention will focus on will be the role of strong and independent constitutional courts in controlling such reactions. My speech will consist of 3 parts. First, I will argue about distinction should be made between real threats and perceived threats. Second, I will try to sketch some guidelines of judicial review that might be exercised by constitutional courts. And third, I will touch upon the standards of review. Short about the threats. It is axiomatic that states should be entitled to defend themselves. However, such self-defense should only be permissible when real threats are present. This does not mean that states may act only when actual negative consequences has occurred, For instance, in case of a military threat against a state, it should be entitled to take preventive measures well before actual shots are fired. However, threats to state should not be identified arbitrarily and should not be an excuse for restricting fundamental rights and basic values of democracy without a very good reason. There is a clear distinction between threats posed by a countrywide epidemic threatening lives of many people and the dangers associated with a seasonal flu. There is a difference between threats to the democratic order of state posed by massive disinformation campaigns sponsored by unfriendly foreign powers and the threat that the governing political parties may be replaced by opposition parties as a result in fair and transparent elections. Of course, in this issue, there are a lot of silent points. For example, how threats to democratic order or order even to the existence of state should be defined, to who decides that the threat is present or no longer present, etc. Short about the scope of review by constitutional courts. It is clear when assessing the legitimacy of state response to threats, constitutional courts may not review the political need or relevance of such a response. The review exercised by constitutional courts should not intervene upon the discretionary powers granted to other branches of state power. Even at times of emergencies, constitutional courts should remain negative legislators. On the other hand, constitutional courts cannot be disjointed from reality and carry out judicial review formally and inflexibly. Constitutional courts may and should decide cases by fully taking into account the circumstances of the present day, and sometimes this might require an adjustment to the usually applied methodology or the applicable standards to ensure that the action of the state is effective. Just two brief examples from the case law of the Latvian Constitutional Court where I fulfill my duties. In a series of cases concerning the constitutionality of various restrictions that were imposed to combat the spread of COVID-19 disease, the Constitutional Court found that in circumstances when it was essential to ensure the ability of the state to adopt decisions rapidly, and on the basis of frequently changing data, it was justifiable not only to delegate the legislative powers to the executive branch, but also to allow adopt legislative acts without detailed consultations with experts and potentially affected parties. Second, in a number of recent cases heard at the Constitutional Court of Latvia, it has referred to the current geopolitical situation, namely attempts of our unfriendly neighbor to exert its influence in our country, to motivate the need for various measures aimed at the protection of democratic state of order. Now very short about standards of judicial review. If constitutional courts were to assess the legitimacy of states' reactions to threats by using the standards applicable in times of peace and calm, it is likely that they would find many such restrictions to be unconstitutional. This would clearly paralyze the decision makers and render states defenseless. However, courts need a legal point or reference to adjudicate cases. One option could be for constitutional courts to examine whether states have not acted arbitrarily. This evaluation could be a useful starting point, but most likely it would not be sufficient. Therefore, my proposal is to use the rule of law as a benchmark for measuring the legitimacy of governmental actions during emergency. This, of course, doesn't mean that we have to go through all the list of rule of law checklists prepared by the Venice Commission, just because some elements of the rule of law are simply incompatible with situations where there is a need for a rapid decision-making. For instance, stability of legal system, protection of legitimate expectations may need to be set aside in true emergencies. However, there are some elements which cannot be fully abandoned even in times of emergency. For instance, the requirement that the actions of the executive branch should always be in line with the Constitution and other laws remains valid even in times of emergency. In this respect, again, the example of the COVID-related jurisprudence of the Latvian Constitutional Court is useful. While the court accepted that emergency circumstances may justify the delegation of legislative powers to the executive, anyway, the parliament fully retains the right to overrule any restrictions imposed by the executive. In other words, parliament still controlled executive. Conclusions. In short, real threats faced by democratic states frequently require extraordinary solutions. Courts, and in particular constitutional courts, ought to retain full control over the legality of the solutions chosen by other branches of the state power. The assessment of constitutional courts should not be a formal. When exercising the judicial review, constitutional courts should remind the guardians of the core elements of the rule of law, which may not be diverged from even in emergencies. Ladies and gentlemen, I thank you for your attention, and let me wish to all of us that there would be no need to discuss emergency powers in the nearest future. Thank you.
Merci beaucoup, chers collègues. Pour la première intervention,
Muchísimas gracias, colegas, por la primera intervención.
les modérateurs que je suis, j'étais un peu défavorisé.
El moderador que yo soy, yo fui un poquito atrás.
J'ai commencé à voir l'interprétation au milieu de l'intervention.
Yo empecé a tener la interpretación en el medio de la intervención.
Mais ce qui est important, c'est que vous puissiez avoir tous les messages.
Pero lo más importante es que ustedes tuvieron
Merci,
el
cher
mensaje.
collègue.
Muchísimas gracias.
Nous prenons Monsieur Rizine Robert,
Ahora tomamos al señor Rizine Robert,
qui est le président de la Cour suprême de la République du Malawi.
quien es el presidente del Corte Suprema de la República de Malawi.
Collègue, vous avez la parole.
Ahora tiene la palabra.
Thank you very much, Mr. Moderator, and thank you very much, my colleagues on the panel. And I appreciate all the distinguished delegates here present. Like the previous speaker, I would like to acknowledge the hospitality of our hosts here in the Dominican Republic. We've been looked after very well since we arrived, and we appreciate that very much. The theme for this panel 10 is constitutional courts in times of democratic peril. I think that's what the program will show. And what we are going to talk about particularly is about the independence of the judiciary, or judicial independence, if you like, and personal safety. I have a narrow interpretation of that topic, and so I'll confine my remarks to a very narrow compass, considering also the time constraints that we have been given to talk about this, and perhaps also to allow for intervention from the distinguished participants. First of all, judicial independence is something that we all talk about, that we are well aware of, and that we realize that judicial independence is a cornerstone of justice, is a cornerstone of the rule of law, and therefore judicial independence must be very, very secured, very, very specially guarded, so that justice can be allowed to flow, so that the rule of law can be allowed to flow. And independence of the judiciary is a constitutional imperative, and it is entrenched in most of our constitutions. It is not a luxury, it's a necessity. It must be there. That's why it is entrenched in our different constitutions, to ensure that everyone is duly protected by judicial powers under their different constitutions. On the other side, when we talk about judicial independence, we must not forget judicial accountability. And judicial accountability is considered as the other side of the coin. So judicial independence and judicial accountability are said to be two sides of the same coin. There was mention that what are the guarantees for judicial independence? The Constitution tends to provide guarantees for judicial independence. But guarantees in word only is not enough. Guarantees of judicial independence must also be in action. I think an assessment of the different constitutions will show the different guarantees that would be there. But what this topic is talking about, I think, is about judicial independence and personal safety. And in terms of personal safety, I viewed it as the personal safety of the judicial officers who claim the authority of judicial independence. There are, in recent times, growing threats to judicial independence. And usually, those threats come through the hidden side of judicial accountability. People will say that they are pursuing judicial accountability, but in the process, they are threatening judicial independence, as if the judicial accountability and judicial independence are diametrically opposed. On the other hand, on the contrary, these must live together because they are both constitutional imperative. I have a specific case of personal safety of judicial officers in a constitutional court in my country. In 2019, we had an important constitutional matter, which was looking at the petition of a presidential election, challenging the election of a president. And during that time, you can imagine the emotions that were associated with it, because it's a serious matter. And therefore, the judges had to be protected. They had to be provided personal safety. And what happened at the time was that because of the serious nature of the matter and the motive nature of the matter, there were threats to the independence of the judicial officers, particularly those who were sitting in that case. So that on one occasion, as they were driving in a police escort guided convoy, they were stoned by some members of the public, to the extent that two of the judges, there were 5 members of the panel, but 2 of their vehicles were badly damaged as they drove to their court in order to deliver a very crucial ruling. It was so bad that the police escort actually sped off and disappeared. But eventually the judges ended up at the court. And even at the court, stones kept raining on their courthouse, to the extent that some of them began saying final prayers, and some of them sending final messages to them, because there was a real threat that that was the last day of their lives. What happened then was that one of the judges picked up a call to the military barracks, which was nearby, and within 10 minutes, the military took over the protection of the judges. This is just to exemplify that judicial independence, exercise of judicial independence, can bring along a lot of threats. But those threats, those dangers to personal lives of the judicial officers should not take them away from the focus of the job. It's a terrible thing. It is the duty of the state to provide appropriate personal security to protect the judicial officers. It is the duty of the people who are responsible for the judges to provide personal safety of the judges. So it's important that in times of democratic peril, the personal safety of the judges should be given paramount importance, paramount attention, even as we ensure judicial independence. And I can only conclude by saying that while the judicial officers' personal safety is threatened, they should remain focused on their duty and not abandon their role, like what happened in the example that I've given. I think for the moment, let me stop there, and I do expect that there will be questions at that time, then we can respond. Thank you, Mr. Moderator.
Merci beaucoup, chers collègues.
Muchísimas gracias, colega.
Nous allons revenir quand il y aura des questions pour donner de plus amples éclaircissements.
Más tarde vamos a tener preguntas para así o usted puede dar más detalle.
C'est le tour du collègue Adelino Manuel Muchanga, qui est le président de la Cour suprême du Mozambique.
Ahora es el turno de nuestro colega Adelino, que viene de Mozambique.
Thanks, Chair. Dear colleagues, panelists, ladies and gentlemen, allow me also to convey the greetings from Mozambique. And for those who don't know where is Mozambique, Mozambique is a country in the southern part of Africa. It's a relatively big country. I was talking with a colleague here, and he was saying that the population is 1.2 million, 1.7. Mozambique is 35 million people, but it's a huge country. It's around 800,000 square kilometers. Talking about independence of the judiciary, maybe I should start from the beginning. The country became independent in 1975. Under the Constitution of 1975, we had the principle of unity of power. So we have a national parliament as the supreme branch of the government, which means that the other two branches had to report to the National Assembly. So the independence of the judiciary was limited. Only in 1990, we had the new constitution, and that constitution introduced huge changes in the structure of the state. We had from then rule of law and multi-party democratic state. We also had in 2004 another constitution reinforcing the rule of law and the democratic principles. So the Constitution of Mozambique provides a strong framework of legal judicial independence, the principal separation of powers. The judicial is an independent branch co-equal to legislative and executive branches. The Constitution also guarantees the independence of judges and explicitly guarantees that in the exercise of their functions, judges only have to obey the Constitution and the law. They must be impartial, cannot be removed, suspended, or dismissed, except in cases established by law. In short, the judges enjoy security of tenure and are bound exclusively by the Constitution and the laws. There's one important guarantee in the Constitution of Mozambique, that is, the independence of the judiciary should not be amended, even in future amendments of the Constitution, unless to improve the independence of the judiciary. So you cannot amend the Constitution to undermine the principle of independence of the judiciary. We also have a self-governing body, the Judicial Service Commission, which is in charge of the career of judges, appointment, removals, transfer, promotion. We have a legal framework which is in line with the spirit of UN basic principles on the independence of the judiciary. We are also part of Commonwealth, which means that the Commonwealth Lightmare House principles also apply to Mozambique. The court decisions are binding and prevail over the other authorities' decisions. And recently, in 1917, we had an agreement with the government to establish what we call financial independence of the judiciary. The budget is allocated to the Supreme Court, and then the Supreme Court, in its terms, allocates the budget to lower courts of the country. After 50 years of independence, what I can say that the judicial independence now is a reality, but from experience, I might say that in my opinion, judicial independence is always under construction. It's a concept under construction. We ought to involve not only the other branches of state, but above all, we have to involve the civil society, the political parties, the media, the citizens. All those have to understand the importance of the judicial independence. For example, in 2024, last year, after election, we had a crisis in Mozambique. And then a new president elected, the leaders of the opposition reached an agreement to try to solve the problem. And then they started what they call a national inclusive dialogue. And that agreement now is a law. Well, they called a memorandum, then was transformed to become a law. In the terms of reference of the dialogue, we have two issues. One is the independence of the judiciary. And second is the financial independence of the judiciary. But those two issues were not brought by the judiciary. It was the society, the civil society, the opposition parties that raised the issues and introduced it in the national dialogue. That's why I'm saying that the judicial independence is something that under construction. You have to involve the civil society, the opposition leaders, the media, the citizens themselves. Then they will make the necessary pressure to the other branches of the government so that the necessary changes are introduced. So the theme of safety of court officials, as my colleague of Malawi said, is also an issue in Mozambique. As I mentioned, we had I'm bringing this example, we had elections in 2024. And after that, we had a lot of protests. I think you may have seen in the news a lot of riots throughout the country. And the judges reported to have been receiving threats, namely via cell phones. We had some court buildings destroyed. completely destroyed or partially destroyed. The protesters also targeted the houses of the judges. In total, we had something like 17 court buildings that were targeted by the protesters. So this means that the independence of the judiciary and the personal safety of the judges are linked. And intimidated judges might think twice before taking a decision, especially when powerful interests are in case. The judge might seek to avoid political sensitive cases, and this, of course, is a dangerous erosion of the judicial independence. I'm saying that this electoral crisis taught us a lesson. Personal safety of judges is linked to independence of the judiciary because we cannot expect judges to be independent if they are not safe. So we took some measures, and we are considering actively implementing other measures to enhance the judicial independence and physical security of judges and courts. We have a protection protocol which we established with the police to ensure that in some cases we may have the support of the police units. This includes close coordination with law enforcement. For example, in some cases we had to engage police escort. I'm referring to the situation of last year, but also in the past we had some cases where very sensitive. We have a dedicated unit to assist the judges. Whenever the judges report a threat, immediately we have this police unit involved. We are also reforming our legal system to boost the structural independence of judiciary and also to deal with the safety of court officials. Actually, we are preparing a special law with the safety of the court officials. Also, this involves capacity building and training. And actually, last year, we involved some of our judges in special training involving it so that in any situation they are able to use guns, for example, to defend themselves. So this year, for example, we have a group of judges who are taking, it's not military training, but is a kind of training to prepare the judges so that they can deal with the situation of threats if need be. In conclusion, I wish to leave you with a message of hope. Even with those challenges, Mozambique judiciary is strong. We respect the constitutional values. Judges have been delivering justice even in difficult times. Judicial independence is a flame that must be kept alive when the winds of difficult blow. To my colleagues, I urge you also to stand in solidarity. The experience I described is not only of Mozambique. Around the world, judiciary, especially those in transitioning democracies, are coming under similar pressure. We must support one another through networks of judicial councils, bar associations, international forums like this. When a judge in one given country is attacked or threatened, let us raise our voice to condemn it. When best practice emerge in one region, such as measures to ensure the security of judges or court officials, let's share those experiences openly to the benefit of all. Let us move forward together with solidarity, determination, and innovation to build judiciaries that are truly independent and truly safe, capable of delivering justice today and for generations to come. Thank you for listening.
Merci beaucoup, chers collègues. Nous passons au président Ilir Rusi, qui est le président du Conseil supérieur de la magistrature de l'Albanie.
Quien es el presidente del Corte de Supremo de Albania.
High Judicial Council of Albania, actually.
Buenos días todos y salud para todos. Un día maravilloso para todos. Yo hablo poco español, de esta manera lo digo una otra cosa. Do të flas në gjuhën shqipe, për faktin sepse jo se është gjuha ime e shtetit tim, por do jetë gjuha e Kongresit Botëror të Ardhshëm në 2027 që do të zhvillohet në Shqipëri.
So, hello everyone. I will speak in Albanian, not only because it's my native language, but also because the next World Law Congress is going to be held in Albania in 2027.
Edhe për diçka tjetër, kjo që ju thash ishte ideja ime, kjo që do t'ju them tani është ideja e profesor Berberit.
This was my idea. What I'm going to say next is actually the idea of Mr. Professor Berberi, who is here in the panel.
Sepse kam zakon që gjërat që nuk janë të mijat, nuk I them si të mijat.
Because I am accustomed to say things that are not actually mine, but I will, let's say, appropriate them.
Profesor Berberi tha që tingujt e gjuhës shqipe tingëllojnë si tingun e gjuhës latine. Nëse kjo është e vërtetë, do na I thoni ju.
Mr. Berberi said that Albanian sounds a little bit like a Latin language, so I don't know, maybe you can confirm that later.
Prezantimin tim do ta bëj në mënyrë tjetër, edhe të vetes.
I am going to present myself in an alternative way.
Ky është simboli I institucionit të cilët jemi ne.
This is the symbol of the institution that I represent.
Këshilli I Lartë Gjyqësor.
High Judicial Council of the Republic of Albania.
Këshilli I Lartë Gjyqësor sot është
The High Judicial Council today is in Santo Domingo, Dominican Republic.
Zoti Hado, gjyqtar apeli,
Mr. Hado, a career judge from the appeal court.
Zonja Plaku, gjyqtar e shkallës parë, Tiranë.
Mrs. Plaku, a judge from the district court of Tirana.
Zoti Kurushi është gjyqtar I gjykatës së lartë, por nuk është prezent në Santo Domingo sepse I kemi lënë Këshillin Gjyqësor për të ndjekur punën e këshillit.
Mr. Kurushi is not here with us today. He is a judge from the Supreme Court of Albania. He is in Tirana, following the other works that the council has to do.
Është zonja Muçi, gjyqtare e apeli.
Ms. Muçi, who is a judge from the appeal court.
Zonja Muçaj, gjyqtare e shkallës parë administrative.
Ms. Muçi, who is a judge from the administrative court of Tirana.
Zoti Koça, gjyqtari I shkallës parë I përgjithshëm.
Mr. Koça, judge from the district court.
Është zoti Tabaku, avokat, antar I Këshillit Gjyqësor.
Mr. Tabaku, lawyer, advocate.
Zoti Bajri, avokat, antar I Këshillit Gjyqësor.
And also Mr. Bayri, who is a lawyer from the members of the advocates in the High Judicial Council.
Zonja Theodori, përfaqësuese e shoqërisë civile, Viola, antar e Këshillit Gjyqësor.
Ms. Teodori, who is coming from the ranks of the civil society members in the High Judicial Council.
Sonja Rupa, profesoresh, universiteti dhe zëvendësëkretare e Këshillit Lagjësor.
And Ms. Rupa, who is deputy chair of the High Judicial Council, and it's coming from the ranks of the academia. She's a professor, a law professor.
Dhe këta kanë me vullnetin e tyre më kanë zgjedhur mua kryetar të Këshillit Lagjësor.
These persons have elected me chairman of the High Judicial Council of Albania.
Kështu që unë nuk jam Ilir Rusi, por jam një nga anëtarët e Këshillit Lagjësor dhe ne jemi Këshilli Lagjësor.
So I'm not going to speak only on my behalf, but on behalf of all the members of the council.
Dhe Këshilli Lagjësor është një organ I ri kushtetues që redhoi një pakete të re ligjore që quhet reforma ndërësimi.
The High Judicial Council is the new constitutional body that was created in the spirit of the judicial reform in Albania.
Dhe secili prej nesh ka një mandat 5 vjeçar. Pa të drejtë për të rritje.
All of us have a mandate of 5 years without the right to be re-elected.
Kjo formulë përbërje është nga magistrat, siç e përmenda, nga avokat, jurist avokat, jurist shoqëri civile dhe jurist pedagog. Unë jam pedagog universitet.
So this composition is based upon the law, and it means that the council has members from the judges, from the academia, from advocates, and from the civil society. Myself, I am coming from the ranks of the academia. I'm a law professor.
Dhe me qenë se jemi në një universitet ku zhvillohet një kongres, jam I familiarizuar me auditorët.
And since we are in the auditorium of a university, I am very familiar to these premises.
Por Këshilli sot më vuri një kufizim. Sepse unë zakonisht nuk lexoj ku flas, por dje Këshilli ka marrë vendim dhe ka hartuar përmbajtjen e kësaj që do lexoj dhe kështu që në respekt të tyre.
I have, let's say, a limitation from other members of the councils. I usually don't follow what's written on paper, but today I will do so.
Po kur ta përfundoj së lexuari, natyrisht do them diçka nga mendja dhe improvizimi.
But when I finish reading what I have prepared today, I will for sure say something that is just improvised.
Dhe këto janë disa fjalë të cilat ne I përmbledhëm dje në pjesën e vjetër të salonit.
So these words that I'm going to say now were all prepared yesterday in the colonial zone of Santo Domingo.
Pra bëmi mbledhje informale me pak.
We had an informal meeting.
Në çdo demokraci të konsoliduar dhe të shëndetshme, gjyqësori nuk është vetëm I pushteti I shkëputur dhe I pavarur, por është mbi të gjitha një garantues I drejtave themelore.
In every consolidated and healthy democracy, the judiciary is not merely a separate and independent power. It is above all a guarantor of the fundamental rights and freedoms of individuals.
Një gjyqësor I pavarur është një gur themeli I shtetit të së drejtës dhe parimeve kryesore të tij. Ai garanton që askush, qoftë me pushtet politik, ekonomik apo çfarëdo ndikimi tjetër, nuk qëndron mbi ligj.
An independent judiciary is a cornerstone of the rule of law and its core principles. It ensures that no one, regardless of political power, economic status, or any other form of influence, is above the law.
Në Shqipëri, ndryshimet dhe risitë në sistemin e drejtësisë në vitet e fundit kanë qenë domethënëse. Reforma në drejtësi ka synuar jo vetëm ngritjen e institucioneve të reja dhe organizimin e strukturave ekzekutive, por mbi të gjitha garantimin e drejtësisë të pahashme, të besueshme dhe të mbrojtur nga çdo ndërhyrje.
In Albania, the changes and innovations in the justice system in recent years have been significant. The justice reform has aimed not only to establish new institutions and reorganize existing structures, but more importantly to ensure an impartial, trustworthy justice system that is protected from external interference.
Këshilli Lagjësor ka luajtur dhe vijon të luajë një rol kyç në këtë proces, nga krijimi dhe konsolidimi I kapaciteteve institucionale deri te garantimi I pavësisë dhe mirë administrimi I territorit.
The High Judicial Council has played and continues to play a key role in this process, from the creation and consolidation of institution capacities to ensuring the independence of judges and the effective administration of the judiciary as a whole.
Ndërsa flasim për pavarësinë si koncept kushtetues, nuk mund të neglizhojmë një aspekt thelbësor të saj, sigurinë personale të gjyqtarëve.
However, when we speak about independence as a constitutional concept, we cannot overlook a crucial aspect of it, the personal security of judges.
Siguria personale është parakushti i domosdoshëm për ushtrimin real të pavarësisë gjyqësore. Një gjyqtar që ndihet i kërcënuar, intimituar, i ekspozuar apo i pambrojtur, është një gjyqtar pavarësisht profesionalizmit apo ndeshmërisë së tij, nuk mund të ketë në ushtrim e funksionit të tij, nuk është i ligjit të gjykojë në mënyrë të drejtë.
Personal security is an essential prerequisite for the genuine exercise of judicial independence. A judge who feels threatened, intimidated, exposed, or unprotected is a judge who, regardless of their professionalism or integrity, is not truly free to judge fairly and impartially.
Për fat të keq janë evidentuar dhe vijojnë të evidentojnë raste ku gjyqtarët janë ndjetë të ekspozuar ndaj presime të ndryshme, qoftë për shkak të natyrës së së apo për shkak të përfshirjes së interesave të aktorëve me ndikim politik apo ekonomik.
Unfortunately, in Albania, there have been and continue to be instances where judges have felt exposed to various pressures, whether due to the sensitive nature of the cases they adjudicate or because of the involvement of actors with political or economic influence.
Në këtë situatë, ne si Këshilli Lagj Gjyqësor vendosemi përpara një përgjegjësie shumë madhore. Të garantojmë që gjyqtarët në Shqipëri të ndihen të mbrojtur në ushtrimin e detyrave të tyre.
These situations place a clear responsibility before the High Judicial Council to ensure that judges in Albania feel protected in the performance of their duties.
Këshilli Lagj Gjyqësor, në përputhje me konceptet e tij kushtetuese ligjore, është përgjegjës për disa procese të rëndësishme të lidhura me pavarësinë, mbrojtjen dhe integritetin e gjyqësorit.
Accordingly, the High Judicial Council, in line with its constitutional and legal responsibilities, is in charge of several important processes related to the independence, protection, and integrity of the judiciary.
Si për shembull, procesin e vlerësimit etik dhe profesional të gjyqtarëve, mbi të cilën mbështetet zhvillimi i karrierës së gjyqtarëve, bazuar në kritere të qarta, transparente dhe meritokraci. Njëta në detyrë e gjyqtarëve në Shqipëri është procesi i ka në përmbajtje, një stër verifikimi është pasurisë figurë pas standardet të procesit të vetimit.
Including the process of ethical and professional evaluation of judges, which underpins judicial career development based on clear, transparent, and merit-based criteria. Judicial promotions in Albania involve thorough asset and background verification in line with the vetting standards that have been already implemented.
Zbatimin e disiplinës dhe forcimin e llogaridhënies për të siguruar që gjyqtarët të veprojnë sipas standardeve më të larta të etikës dhe mos ndikohen nga presionet e jashtme.
The enforcement of discipline and strengthening of accountability to ensure that judges act according to the highest ethical standards and are not influenced by external pressures.
Mbrojtja institucionale të gjyqtarëve kur ata bëhen objekt presioni politik, mediatik apo në çdo natyre tjetër përmes mjeteve që parashikon ligji, siç janë reagimet publike.
The institutional protection of judges when they become subjects of political, media, or other forms of pressures through legally provided means such as public statements.
Zhvillimi dhe përmirësimi e mekanizmave të brendshme për ruajtjen e pavarësisë, zhvillimi i komunikimit me publikun, rritja e transparencës në proceseve vendimarrëse, vendosja e funksioneve dhe përdorimit të një sistemi rastësor të shpërndarjes së çështjeve në gjykata në formë elektronike.
The development and improvement of internal mechanisms to preserve independence, such as enhancing communication with the public, increasing transparency in decision-making processes, and implementing and utilizing a random electronic case assignment system in all courts.
Pavarësia e gjyqësorit nuk është një objektiv i fituar një herë për gjithmonë, ai është një proces i vazhdueshëm që duhet mbrojtur dhe forcuar çdo ditë.
Judicial independence is not a one-time achievement. It is a continuous process that must be protected and strengthened every day.
Kjo nuk është vetëm një përgjegjësi e Këshillit Lagj Gjyqësor, por një angazhim i përbashkët i gjithë aktorëve, institucioneve drejtësisë, institucioneve tjera shtetërore, shoqërisë civile dhe medias.
This is not only the responsibility of the High Judicial Council, but a shared commitment among all stakeholders, justice institutions, other public institutions, civil society, and the media.
Përmes një bashkëpunimi të ngushtë dhe qasje konstruktive, mund të ndërtojmë një gjyqësor që i shërben sa më denjësisht interesit.
Through close cooperation and a constructive approach, we can build a judiciary that serves the public interest with dignity and integrity.
Do a theksoj se ku mbrojmë sigurinë e gjyqtarëve, nuk mbrojmë vetëm individët e caktuar të veshur me statusin e magjistratit. Ne mbrojmë parimin e pamshmërisë dhe pavarësisë, të drejtë për proces të rregull dhe ligjor për çdo person që janë bazat e shtetit.
In conclusion, I would like to emphasize that when we protect the security of judges, we are not only protecting individuals vested with the status of magistrates. We are protecting the principle of impartiality and independence, the right to due process for every person, which are the very foundations of the rule of law.
Tashmë u lirova nga kam veshur kostum, po u lirova nga kostumi që më kishte veshur Këshilli për të thënë këtë fjalim.
So this was my public statement, and now I will say something else, which is like off the records, let's say.
Dhe tani do të flas me fjalët e mia ashtu si pedagog që jam, jurist pedagog.
I will say something in my own words, as in line with my role as law professor.
Të pavarur nuk ka asnjëri në jetë.
No one is truly independent and purely independent.
Varet nga besimi që kemi, varet nga Zoti apo nga ligji.
It depends on our own faith and on our faith in God.
Në këtë rast magjistrati do të ketë dy, besim në Zot dhe besim që e një ligj.
So the magistrate must have both faith in the law and also faith in God.
Pa ajo që të bën pavarur është integriteti.
What really makes a judge independent is integrity.
Integriteti I gjithë secilit prej nesh.
The integrity of each one of us who are part of the system.
Dhe më tej integriteti institucional duke qenë ne me integritet.
And which is followed by institutional integrity.
Integriteti nuk është një diplomë që merret në universitet, meqense jemi në mjedis universitar.
Integrity is not a degree that is given to you by a university.
Nuk ta dhuron Zoti, nuk ta dhuron ligji.
It's not a gift from God or from the legislation, from the law.
Këtë ne mund ta diellim dhe ta kultivojmë dhe ta rrisim ne çdo ditë.
It's something that must be really increased and grown based on our own capacity.
Pra është në dorën tonë.
So it's really in our hands.
Dhe nëse ne kemi integritet, kjo ka puna jonë gjallë besimtet e tjera.
And if we have integrity, then we will achieve the public trust.
Po edhe nëse në një moment caktuar publiku ka besim te ty, kjo nuk do të thotë që do të ulësh vigjilencë për të humbur integritetin.
And even if the public you have gained the public trust, one must not, let's say, not follow and not decrease the level of integrity. He must always continue to grow and to follow the integrity that he has.
Dhe unë do thoja pavarësi baras integritet. Integritet baras pavarësi.
So I would say that integrity is equivalent to independence, and independence is equivalent to integrity. Thank you very much.
Merci. Je vois qu'il nous reste encore 1 heure. Hein?
Muchas gracias. Todavía nos
C'est juste
falta
quelle heure?
1 hora. ¿Es hasta qué hora?
Il reste 50. 50. OK. C'est bon. Nous passons au 5e intervenant,
Y
qui
ahora,
est M. Roberto Molina. Il est magistrat à la Cour constitutionnelle de Guatemala.
y ahora vamos a pasar a nuestro quinto integrante, que es el representante de la República de Guatemala.
Gracias. Trataré de ser muy breve por el tiempo que ha transcurrido. Realmente mi tema es con respecto a las amenazas que realmente tienen nuestros países en el sistema judicial, que puede llegar a afectar el sistema político de un país. En Guatemala, el Tribunal Constitucional tiene a su cargo el cuidar de la norma constitucional y cuidar del orden jurídico del país, lo que indudablemente nos hace converger en el campo político puramente. Para eso, el Tribunal Constitucional debe estar conformado por profesionales de alta calidad, no solo en el aspecto puramente jurídico, sino en el político. Con esto quiero decir que el tribunal o el magistrado constitucional debe saber ocuparse de la política, pero no hacer política, o sea, saber ser árbitro y no jugador en los conflictos políticos que se dan en un país y que pueden llegar a amenazar la independencia. O sea, se requiere que el juez constitucional adquiera una verdadera legitimación para que obtenga el respeto de la población en las resoluciones que emita. Para esto es indispensable que el juez constitucional o el tribunal pueda realmente saber cómo autolimitarse. ¿A qué me refiero con esto? Cuando el tribunal se dedica a resguardar el orden constitucional, es que deje a los demás poderes del Estado ejercer sus propias competencias y no pretender invadirlas. Y que sepa que su actuación es excepcional. O sea, debe dejar a los políticos resolver los conflictos políticos y solo en aquellos casos extremados, cuando ya se han agotado las vías ordinarias para poder solventar aquellos conflictos políticos, es que debe de ejercerse la tutela constitucional. Recordemos que el poder realmente radica en el pueblo y que es delegado en los 3 poderes del Estado para poderlo ejercer, y por eso debe de haber un total respeto al orden constitucional para poder lograr la paz y el bien común. Es indudable que en nuestros países siempre existan los abusos o excesos del poder o las omisiones que se dan cuando ya están ejerciendo el poder los gobernantes. Y la sujeción a la ley debe ser no solo de los gobernados, sino de los gobernantes. Digamos que la esfera importante en nuestro sistema judicial es poder solucionar los conflictos de orden político con criterios estrictamente jurídicos. Esto significa pues de que los jueces constitucionales, no obstante que como seres humanos tienen toda la libertad de tener una ideología, una religión, cualquier tipo de gustos, incluso los deportivos de un equipo y no otro, esto no puede hacerlos poder ejercer aquellos gustos o aquellas decisiones de orden personal a la hora de emitir sus resoluciones. O sea, debe de controlar aquellas tentaciones de poder invadir esferas que no le corresponden. Es muy conocido en mi país que se le llame a la Corte de Constitucionalidad la Corte Celestial, porque también los jueces cometen esos abusos y va más allá para poder tener la intención de tener el control político del país. Y eso no debe ser así, porque para eso están las esferas de cada uno de los poderes del Estado. En mi criterio, el pilar más importante de un sistema democrático es precisamente lo que se ha hablado hoy, que es la independencia judicial, que cotidianamente está muy amenazada. Y no solo por el campo político, también en el campo del narcotráfico, del crimen organizado y también de intereses económicos. Entonces, lo que prevalece en un juez constitucional pues es aquella valentía, aquella independencia, aquellos principios y valores que acaban de mencionarse para poder ejercer una judicatura absolutamente independiente, y solo así se podría vivir en un verdadero Estado de Derecho. Lamentablemente no tenemos tiempo. A mí me hubiera gustado comentar dentro del tiempo que nos habían establecido cosas muy importantes que han pasado en el país y que han sido mundialmente conocidas, como es el autogolpe de un gobernante en 1993, Jorge Serrano Elías, que se autodió un golpe de Estado, y también las esferas que se dieron en el año pasado, en el 2023, con la elección del presidente actual, Bernardo Arévalo, que ha sido un verdadero conflicto desde que asumió la presidencia, que esto lo permitió el Tribunal Constitucional, que es precisamente cumpliendo su función de resguardar el orden constitucional. Espero que en el futuro podamos tener más oportunidad de platicar sobre el verdadero rol de un juez constitucional. Muchas gracias.
Merci beaucoup, chers collègues. Et enfin, nous passons au dernier intervenant, M. Sokol Berberi, qui est de l'Albanie, mais lui, il intervient beaucoup plus comme juge émérite.
Muchísimas gracias, colegas. Y ahora vamos a pasar a nuestro último integrante, que es de Albania y que va a hablar como juez.
Merci beaucoup, Monsieur le Président. Je suis très heureux et je suis honoré de participer dans cette discussion, dans ce panel. Mais excusez-moi, je vais parler en anglais. Si j'ai besoin, on peut avoir l'aide de vos compagnies. Merci beaucoup. So I have to be fair now because we are two Albanian in the panel and we took a lot of time. And so I'll try to be brief. While I was reflecting about the topic, I followed some development in US, the judiciary in the US. And in the face of some calls for impeaching the judges for their rulings, we have a reaction by the Chief Justice Roberts of the US Supreme Court. And I quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose." And I was reflecting that probably it's worth to reflect and to bring these important principles about the independence of the judiciary. And the premise for that is a key aspect, is the functional immunity of the judges. And we have to reflect what are the safeguards about these principles, functional immunity of the judges. The judges cannot be held liable for opinion expressed or decisions made in the exercise of their judicial duties. So I was reflecting, what are the safeguards in this context, which are related to the criminal liability, disciplinary liability, and civil liability? We have to think for substantial aspects, but also procedural aspect of these liabilities, these safeguards. Let's start with the criminal liability and what are the safeguards about that. First of all, there are the substantial safeguards, the criminal offense. And that took me in my memoir and my time. Well, I used to be a judge of the Constitutional Court in 2008. And we had, through the incidental way, to review a criminal offense, which was article in the Criminal Code 315. And it was about giving an unfair decision. In fact, the language of that criminal offense was not clear and it was ambiguous. And in fact, that left the space for not appropriate external use to the judge, and probably that can influence the judge from the authorities of the states. Or in every decision, there are parties that are not satisfied, and they will try to initiate proceedings. And we decided that the language of this criminal offense was not constitutional. and it was related to these principles. Actually, we split 5-4 because the 4 in the minority, they thought that probably that was not good for the accountability of the judges. But we think that this is the core of the independence of the judges. So this is important from the substantialness. So the criminal offenses that are related to the judges' function, the ruling of the judges. But there are important safeguards, procedural safeguards. So from the institution, they have to control the process when there are proceedings against the judge. We have cases now that took the attention in US context. So if they are in US context, can be everywhere, and we have to reflect it, to be very attentive about that. So there can be, when the judge is arrested, or other means of the proceedings, criminal proceedings, so they have to be safeguarded, and the authority, they have to control that, that process is important. I think the president of the Judicial Council mentioned that, and I think this is important of the council to control it, to check all the safeguards about criminal proceedings. As for disciplinary proceedings, yes, again, so the language for the wrongdoing of the judges has to be clear, not to infringe the principles that are related to the functional immunity of the judges. And I think, again, the role of the Judicial Council, which is the body that has to supervise and is the authority that gives sanctions on disciplinary matters, is to balance that responsibility, but also to respect that principle. And as for civil liability, so there is, we know, but can be undue external influences to the judges according to the civil liabilities. And there is a principle that the judges, they don't have to be civil liable for error in the judiciary. So it is the state. But always, we have to be aware that only when we behave in good faith, when there are misbehavior, wrongdoing, and the judge has to be responsible. But we have to, that is the exception. That is, the principle is so important that the judges don't have to be responsible for wrongdoing on civil matters. So it's a state, and the state has to deal with that and to be responsible. So these are safeguards, and if we reflect about the constitutional reforms that we got in 2016, we have reflected, and actually we addressed that, and there are high standards about these safeguards. But this is normative aspects, and there are institutions to control and to respect that, and I think the Judicial Council is the main body, and it's a institution that reflect the self-government of the judiciary, and there is a institution that has spread in the model applied in Europe, in continental Europe, and it's a guarantee. And at the end, we have to be very attentive to educate the public and to explain that these safeguards are not for the judges, are for rule of law, and they are for respect of human rights, are the respect for the people. So these are not privileged, and then we have to explain and to be transparent about all these safeguards that the judges has to enjoy, not for them, but for the respect of human rights and the rule of law. Thank you.
Merci beaucoup à tous les intervenants, chers collègues.
Muchísimas gracias a todos los intervenientes, a mis colegas.
Il nous reste trop peu de minutes pour les échanges.
Nos queda demasiado pocos minutos para los intercambios.
Je retiens simplement que de toutes les interventions,
Yo tengo de todas las intervenciones,
une constance s'est présentée.
una constancia que presentó.
L'indépendance du pouvoir judiciaire
La independencia del poder ejecutivo,
est
del poder
reconnue
judicial,
dans toutes les constitutions.
está reconocido en todas las constituciones.
Mais le grand problème, c'est comment est-ce que cette indépendance qui est reconnue est articulée.
Pero el gran problema es esa independencia judicial que está reconocida y
Dans
se
son
está
intervention,
articulando.
la présidente Anita de Lettonie
Dans la intervención del Estado de Letonia,
a jugé que même si il y a des garanties, même en période de calamité,
aunque hay garantía en momento de calamidad,
un État de droit doit faire en sorte que les droits et libertés fondamentaux des citoyens soient sauvegardés.
el Estado de Derecho tiene que hacer que se garantiza los derechos de los ciudadanos.
Et pour le président Rizine du Malawi,
Y para el presidente Rizine de Malawi,
l'indépendance du pouvoir judiciaire est une urgence
la independencia del judicial es una
et la pierre
urgencia.
angulaire du système de son pays.
Es la parte angular de su país.
Pour le président Adelino Manuel
Para el presidente de Adelino
de
Manuel,
Mozambique,
de Mozambique,
il a reconnu qu'on ne pouvait parler de l'indépendance du pouvoir judiciaire
reconoció que no se puede hablar de la independencia del poder
tant que le
judicial
pays lui-même n'était pas indépendant.
hasta que el país no era independiente.
C'est pourquoi il a fait remonter d'abord à l'année 1975
Es por esta razón que él mencionó el año 1973,
quand le pays est devenu indépendant.
cuando el país llegó a ser
Et
independiente.
il nous a donné l'évolution de cette notion dans leur constitution.
Y él nos dio la evolución de la Constitución.
En 1990,
En 1990,
à l'occasion de la nouvelle constitution de Mozambique,
cuando llegó la nueva Constitución en Mozambique,
la notion de l'état de droit a été posée.
la noción del Estado de Derecho se
Et c'est
impuso.
en ce moment-là qu'on a commencé à parler de l'indépendance du pouvoir judiciaire.
En aquel momento se empezó a hablar de la independencia del Poder Judicial.
Cette indépendance qui a été renforcée en 2004
Esta independencia que reforzó en 2004
par la nouvelle constitution.
por la nueva Constitución.
Mais il a posé aussi un problème.
Pero también habló de un problema.
Indépendance déclarée, oui.
La independencia declarado,
Est-ce que financièrement, sur le plan budgétaire, est-ce que le pouvoir judiciaire a les moyens d'être indépendant?
en el plan financiero es que si el Poder Judicial tiene un presupuesto para estar independiente.
Pour le cas de l'Albanie,
Por el caso de Albania,
le président du Conseil supérieur de la magistrature,
el presidente superior de la Suprema Corte,
en présentant la délégation,
presentando la delegación,
nous a même implicitement montré la structure du Conseil supérieur de la magistrature de l'Albanie,
nos enseñó la estructura del Consejo,
qui est totalement différente du Conseil supérieur de la magistrature dans mon pays.
que es totalmente diferente del sistema en mi país.
Il est élu pour 5 ans,
Está elegido por 5 años,
mais j'ai aimé la conclusion en tant que professeur.
pero me gustó la conclusión como profesor,
Là, il ne lisait plus.
pero a este
Il y a
momento no
une
estaba leyendo.
partie qu'il a lue
Y hay una parte que leyó
et une partie qu'il a donnée librement
otra parte que él dio libremente
pour tout magistrat de carrière.
para todos magistrados de carrera.
Il sait
Él sabe
que la plume est esclave,
que el bolígrafo es esclavo,
mais la parole est libre.
pero la palabra es libre.
Et quand il a pris cette liberté de parole,
Cuando tomó esa libertad de palabra,
il dit très bien que
él dijo muy bien,
l'indépendance peut être garantie.
la independencia podría
Mais cette
estar mentira.
indépendance dépend d'abord de l'homme, de la personne, du magistrat,
Esta independencia depende primeramente de la persona, del hombre, del
qui
magistrado,
doit tenir compte de son éthique
que debe mantener su ética
et de la foi.
y su fe.
Moi, j'ai aimé personnellement cette alliance-là.
Y, yo personalmente me gustó esta alianza.
On peut avoir de bons textes.
Podríamos tener buenos textos.
Ce ne sont pas des robots qui appliquent,
No son robos que lo van a aplicar,
ce sont des hommes.
son hombres.
Alors, si l'homme lui-même n'est pas intègre,
Si el hombre no es íntegro,
quelle que soit la qualité de texte,
no importa la calidad del texto,
rien ne sera fait.
nada se hará.
Et pour le collègue Roberto Molina,
Y para el colega Roberto Molina,
je prends une phrase.
yo tomé una oración.
Le juge constitutionnel
El juez constitucional
doit faire en sorte que les équilibres entre les institutions soient respectés dans le pays.
debe mantener el equilibrio entre las diferentes partes en el país.
Il gère la vie politique,
Él administra la vida política,
mais lui-même ne doit pas faire la politique.
pero no debe hacer la política.
Il a donné la belle phrase en disant
Done la linda oración en diciendo,
il doit être administrer la vie politique
debe ser un árbitro y puede estar
Como
administrando la vida
árbitro.
política
comme arbitre,
como árbitro,
mais pas comme joueur.
pero no como un jugador.
J'ai aimé ça.
A mí me gustó.
Oui.
Sí, está bien.
Et enfin,
Y al final,
il y a le collègue Sokol Berberi
y on a notre collègue Sokol Neberi,
qui avait promis de ne pas beaucoup parler,
que nos dijo que no iba a hablar mucho,
mais qui a quand même un peu parlé.
pero habló un poco, ¿sí?
Il a touché l'aspect de la responsabilité du juge.
Él mencionó el aspecto, la responsabilidad del juez.
La sécurité du juge doit commencer quand il prend la décision.
La seguridad del juez debe empezar cuando empezó a
Je
tomar
ne sais pas
decisiones.
si en Albanie ça se fait, mais en République démocratique du Congo,
Yo no sé si en Albania eso se hace, pero
cette
en República
sécurité-là du
Dominicana,
juge, c'est dans le délibéré.
en este momento que el juez está deliberando,
Et les juges sont obligés de faire un PV de délibéré
los jueces deberían liberando un poco
pour faire en sorte qu'ils ne puissent pas être redevables.
para que ellos no tienen que ser recíprocos.
Et les collègues ont relevé 3 aspects qui peuvent affecter le juge dans son travail.
Hay 3 aspectos que pueden afectar los jueces en su trabajo:
L'aspect pénal,
el aspecto penal,
l'aspect civil
el aspecto civil
et l'aspect disciplinaire.
y el aspecto disciplinario.
Voilà un peu ramassé de façon linéaire
Es para tomar de manera lineal
les interventions que nous avons reçues
las intervenciones que recibimos
et la parole à l'assistance s'il y a des questions.
y la palabra a la asistencia si tienen unas preguntas.
Merci. OK. Il n'y a pas de questions apparemment.
Al
Et
parecer no hay preguntas.
nous avons consommé notre temps.
También consumimos el tiempo.
Il ne reste qu'à vous remercier pour votre assistance
Solamente tengo que agradecerles por su asistencia
et votre patience.
y también su paciencia.
Merci beaucoup.
Muchísimas gracias.